The Honourable Member for Surrey North.
Thank you, Mr. Speaker. I speak today about Bill C-489 and Act to amend Criminal Code and the Correction and Conditional Release Act. Mr. Speaker, it is a privilege to speak on behalf of my constituents of Surrey North about this important bill. As my honourable colleague a member from Gatineau has pointed out in previous speech, it is rare that we as MPs have the opportunity to discuss something that has a tangible outcome for our constituents, and it is a privilege to be able to bring a Surrey North perspective to this debate. Mr. Speaker, the NDP has a solid history of advocating for survivors of violent crimes, particularly in reference to gendered violence and violence against children. In my own riding, offenders who are released from detention have moved into neighbourhoods where constituents are worried for the safety of themselves and their families. My predecessor, NDP MP Penny Pretty, along with other MPs from British Columbia, have previously proposed measures to assist municipalities in the management of violent offenders. They have called for federal funding for communities who must pay extraordinary costs to monitor these offenders, to support mental health facilities and addiction services, and to provide appropriate housing for the reintegration process. However, Mr. Speaker, lack of funding has not prevented hardworking professionals from addressing this concern. And we've seen from the federal side that over the last number of years of downloading a number of services to the provinces and eventually to the municipalities. However, Surrey's crime reduction strategy has been heralded as the most comprehensive community-based initiative intended to reduce delinquency and reoffense. It builds community capacity to address crime while providing rehabilitation and reintegration assistance to the offenders. Surrey's program has been particularly successful because of the extensive collaboration between law enforcement and correction services, non-profit organization, the Surrey School Board, the Surrey Board of Trade, and other community organizations. I'm also grateful for the professionals who work in rehabilitation and halfway housing services, and I encourage a perspective of rehabilitation and social integration in our justice system. This bill proposes restricting certain offenders from being within 2 kilometers of a house where a victim is present without a parent or a guardian, or being in a vehicle with a person who is under the age of 16 years old without the presence of a parent or a guardian. It also would potentially prevent certain offenders from communicating with any victim, witness, or any other person identified in a probation order, or refrain from going any place specified in the order except in accordance with specified conditions. Mr. Speaker, this is an important bill for violent crime survivors' rights, and it must be examined with needs of survivors in mind. I, along with my NDP colleagues, am in favour of Bill C-489, as we are in favour of any proposal that protects vulnerable members of our society. Although well-intentioned, the structure of the justice system often re-traumatizes the very people it is trying to protect. It is well documented that witnesses and survivors, particularly of gendered crimes and cases involving children, are re-victimized throughout the justice process, particularly when the victim must confront the alleged offender at trial. Once the ordeal is over, the survivor can begin their healing journey. However, imagine a survivor's shock when their offender returns to their neighborhood. The re-traumatization of having to see this person every day could undoubtedly lead to increased mental health issues and challenges to the healing of the survivor. Although victims understand that offenders will eventually be released, it is imperative that they be informed of the release and relocation. Mr. Speaker, research has proven that knowledge about the offender and the rehabilitation of such can be incorporated into the psychological healing journey of the survivor. The knowledge that offender is taking steps to address reasons for their crime and could be relieving to some survivors. Furthermore, information on offender relocation is essential to the development of a safety plan and a general feeling of security. Mr. Speaker, however, as with any proposal that affects Canadian lives, we need to ensure that the bill offers suitable solutions. The NDP proposes that there be extensive consultation with victim rights groups to ensure that Bill C-489 offers adequate and appropriate protection for survivors of violence. I am particularly interested in gaining the perspective of organizations in my communities, such as Surrey Women's Centre, the Centre for Child Development, and Options Community Services. By talking to these frontline service providers, families, and local enforcement agencies, we can gauge whether the bill in its current form will address the needs of most vulnerable to it. Throughout our discussions today, Mr. Speaker, we need to be conscious of the fact that most crimes, particularly sexual assaults, are unreported, and if they are reported, often survivor stories are not believed. Contrary to the strange danger myth, the University of Toronto reports that in as many as 85% of the sexual assault cases, the survivors know their attacker. As found by the Calgary Communities Against Sexual Assault, if children are the target of violence, in 75% of the cases, they know their offender, who are usually a relative or a family member. Mr. Speaker, power imbalance between the victim and offender, and even the victim and the justice services, as well as societal reception of certain crimes, often averts survivors from reporting. This means that many survivors are forced to relive their trauma without closure, justice, and adequate support services. If the offender is a close relative, friend, or a community member, the survivor may be forced to continue to see the offender on a regular basis, reliving the trauma that they first experienced and making them increasingly vulnerable to further violence, Mr. Speaker. Mr. Speaker, today we may not be able to change the lives of survivors of unreported crimes. However, through our discussion, through a debate in this House, we have the power to make a real change in the lives of people we can help. We need to do what we can here in this House to say that the re-traumatization and re-victimization of survivors of violence, particularly women, youth, children, is not okay. We need to protect survivors and empower them to continue their journey of healing. Mr. Speaker, I encourage my honourable colleagues in this House to reflect on these ideas while remaining conscious of the power that we have in our positions as members of Parliament. Mr. Speaker, we need to use this power to support survivors of violent crimes and continue to support tangible solutions for prevention, the justice system, and protection of victims' rights. Mr. Speaker, I encourage my members, the Justice Committee, to look into this bill further, to look at ways how we can protect victims, how we can provide services to the victims of crimes. Thank you, Mr. Speaker.